on the action items or the agenda is item number 9. This is final adoption of ordinance number 1147, amending Title V of the Hobbs Municipal Code requiring abortion providers in the city of Hobbs to comply with federal law. Ms. Valerie Chacon, our Assistant City Attorney.
Good evening, Mayor. Good evening, members of the Commission, City Manager, City staff, and members of the public. My name is Valerie Chacon, and I serve as Deputy City Attorney. I am here for the final adoption of an ordinance amending Title V of the Hobbs Municipal Code requiring abortion providers in Hobbs to comply with federal law. Let me get this. All right. The purpose of this proposed abortion clinic ordinance is to preserve the integrity of the local medical profession by ensuring compliance with applicable law. The City of Hobbs is posed with the concern that abortion clinics are not listed as health care facilities under the Public Health Act, New Mexico Statute annotated 1978, Section 24-1-2. Because they are not listed, they are arguably not regulated by the New Mexico Administrative Code 7.1.7.8, the standard of compliance, which regulates healthcare facilities, i.e., abortion clinics are likely not regulated. This presents a concern for the health, life, and safety of the residents of the City of Hobbs, and that is why we bring forth this ordinance. So this proposed ordinance does not outright ban abortion in the City of Hobbs. It does not outright protect abortion in the City of Hobbs. It does not contradict state law. It does not contradict federal law. But it does require the operator of an abortion clinic to obtain a license. It does require an operator of an abortion clinic to abide by federal law. And it does give this commission the authority to issue, revoke, and reconsider their business license. Federal law. Federal law is the supreme law of the land. The City of Hobbs Commission is bound by oath to support and defend the Constitution of the United States and the statutory provisions codified at 18 U.S.C. Section 1461 and 18 U.S.C. Section 1462, which are the supreme law of the land pursuant to Article 6 of the U.S. Constitution. So we're talking about this federal law. 18 U.S.C. 1461 and 18 U.S.C. 1462 make it unlawful to mail or to use express carrier to deliver any articles or things designed to produce abortion, including instruments, drugs, and medication. This was codified in 1948, but the Congress actually looked at this in let me see if I can make this closer. Oh, gosh. Excuse me. Okay, but Congress actually looked at this federal statute in 1994 and in 1996, after Roe and after Casey. And as you see the lines, the blue colored highlights, that is what's been added to the statute since 1948. And then the red are the strikeouts that have been stricken since 1948. And so, in particular, we're looking at subsection C. In subsection C, it discusses abortion. As you can see, there's no highlights, whereas they're adding language, and there's no strikeouts as if they were repealing anything regarding abortion. So, how did we get here? As I stated, U.S. Congress adopted 18 U.S.C. Section 1461 and U.S.C. Section 1462. And in this section, as I said earlier, it makes it unlawful to mail or use express carrier to deliver any article or things that bring forth an abortion, which include instruments, drugs, medication. Then going forward, in 1973, Roe versus Wade provided that an abortion is a right to privacy stemming from the First, Fourth, Fifth, Ninth, and 14th Amendment. And then in 1992, Planned Parenthood versus Casey actually said, no, Roe got it wrong. It's actually not a right to privacy. Moreover, it's a liberty interest that is protected by the 14th Amendment, the Due Process Clause. And so what I'd like to discuss next is in 1994, as I stated earlier, U.S. Congress actually amended U.S.C. Section 1462. And its amendments, as stated earlier, were not regarding abortion whatsoever. And then once more in 1996, U.S. Congress once more amended this federal statute, which did not concern abortion. So they looked at the statute after the Supreme Court said, yes, abortion was a liberty interest. I'd like to next talk about New Mexico law. In 1919, New Mexico adopted the criminal abortion statute, which was later codified in New Mexico Statute Annotated 1978, Section 30-5-1 through 3. This criminal abortion statute made it a fourth-degree felony to bring forth an untimely termination of a woman's pregnancy absent a medical justification. In 2021, Senate Bill 10 actually repealed the entire criminal abortion statute. And when they appealed it, they never replaced it. They never replaced it with a law that was conferring the right to abortion. Moving forward in 2022, where we stand today, Dobbs versus Jackson's Women's Health Organization actually provides that there's actually no constitutional right to an abortion. As we sit today, we look for guidance as a city. We look towards the federal statute for guidance. The federal statutes say it's unlawful to mail an express carrier and to deliver any things or items that bring forth an abortion. We look towards Supreme Court law, which first said that's a liberty interest in Roe. That's a privacy interest in Roe. And then later said it's actually liberty interest in Casey. And now Supreme Court precedents provides that there's actually no constitutional right to an abortion. So we have federal law saying it's unlawful to put in the carrier or to deliver anything that brings forth an abortion. And then we have Supreme Court case law that says there's no constitutional right to an abortion. So then we look at New Mexico law. As I stated earlier, Senate Bill 10 actually provides that there's no regulation on abortion, and they did not put forth a law conferring the right to abortion. So we as the city of Hobbs are posed with the concern that the abortion clinics are not regulated by the Public Health Act, because they were not listed as a healthcare facility. Therefore, the city is posed with the duty to protect its citizens. Under Article 10, Section 6, subsection D of the New Mexico Constitution, it provides that a municipality which adopts a charter, like the city of Hobbs, may exercise all legislative powers and perform all functions not expressly denied by general law. And by the same token, the New Mexico Supreme Court has previously held that a home rule municipality, like the city of Hobbs, does not look to legislation to grant the power to legislate, but it looks at statutes to determine whether there is any limitations on that power. So today, the regulation of business located in Hobbs, New Mexico, is not a matter of statewide concern. And along with the adoption of Senate Bill 10, has resulted in the existence of no state law expressly denying the ability of the city of Hobbs as a home rule municipality to act on the matter of abortion-related business. And therefore, because we have a legitimate concern to protect the integrity of the medical profession, we ask that, or in this ordinance, we ask that abortion clinics affirm their compliance with federal law. Next, in preparation for today, our office scoured the internet, and we found a couple of published claims. And so I have listed them here today, and I'm asking to address these claims. And so the first claim is, excuse me, let me grab my. So the first claim is that this ordinance is religiously motivated. This ordinance is not religiously motivated. It can easily be argued that if this ordinance was religiously motivated, it would be a complete and total ban on abortion in Hobbs, New Mexico. The motivation behind this ordinance is simple. It's to protect the integrity of the local medical profession by ensuring they comply with all applicable laws. Public claim number 2. This ordinance is a ban on abortion. This ban is not a ban on abortion. Quite to the contrary, this ordinance anticipates that an abortion provider will seek to establish a location in Hobbs, New Mexico. The ordinance calls for an application process and contemplates continued provision of services. The ordinance does not contain a ban, does not contain language purporting to ban, and does not seek to ban abortion in Hobbs, New Mexico. The third claim is that this ordinance mirrors Texas law. This ordinance does not mirror Texas law. The Texas law, often referred to as the Heartbeat Act, which authorizes civil lawsuits against abortion providers in Texas. As can be plainly seen, this ordinance does not authorize civil lawsuits against abortion providers, nor does it impose criminal penalties against abortion providers. It's important to note, a previous draft ordinance was presented to the city attorney's office for consideration. Our office unequivocally rejected that draft of the ordinance, as it was contrary to the New Mexico Constitution. For anyone who knows the attorneys in our office, we don't simply rubber stamp proposed legislation without research and severely scrutinizing against both the U.S. Constitution and the New Mexico Constitution. We have sometimes been jokingly referred to as a Department of No. To address the public claim number 4, this ordinance prohibits care for miscarriages. This ordinance does not prohibit care for miscarriages. Anyone who has had a miscarriage can attest that treatment for miscarriages is a routine and recognized medical procedure. Members of our office can attest to that fact. The ordinance in no way interferes with the medical procedure. It is a business ordinance that regulates licensure alone. Excuse me. Published claim number 5. This ordinance denies women's health care. This ordinance does not deny women's health care. Quite to the contrary, this ordinance aims at protecting women's health care and the integrity of the local medical profession. One simply has to look at the stated purpose outlined in section 5.52.010 of this ordinance. To address published claim number 6, abortion services are legally protected via state law. Abortion services are not legally protected via state law. It's important to note that Senate Bill 10 repealed the criminal abortion statute. Following this move, New Mexico legislature never enacted any statute conferring the right to an abortion. Put plainly, there's not a law conferring the right to abortion or denying the municipality's ability to regulate abortion businesses. And lastly, published claim number 7. Reliance on federal law is dubious. Relying on federal law is not dubious. As previously explained, although the federal law in question was codified in 1948, it has since been amended by the U.S. Congress in 1994 and again in 1996. Both amendments came post-Roe and Casey. This shows the congressional intent not to repeal those federal statutes. And with that, I'll stand for any questions.
Questions or comments of the commission?
Mayor, I have one brief comment, if I may.
Sure.
There
Please
was
recognize yourself.
Yes, sir. Ephraim Cortez, and I serve as the city attorney for the city of Hobbs. I'd like to address just an earlier comment. It raises a procedural question or concern relative to this ordinance, and I think the record needs to reflect the accuracy of the process. It was raised or questioned whether or not there's actually an appeal process enacted in the ordinance. And so what I would submit to the commission is that your appeal process is already codified in Article 3, Public Hearings of Chapter 2.04, which governs all of the appeals authorized under the Hobbs Municipal Code. Thank you.
Any other questions or comments from the commission? If there are none, I will then open it up for public comment. We will go under the same policy as we did previously.